Everyone. So this is the continuation of the report about the Republic Act 9165, an act instituting the Comprehensive Dangerous Drugs Act of 2002, repealing Republic Act number 6425, otherwise known as the Dangerous Drug Act of 1972, as amended providing funds therefore and for other purposes. Section 27. Criminal liability of a public officer or employee for misappropriation, misapplication, or failure to account for the confiscated, seized, and or surrendered Dangerous Drugs Act, plant sources of dangerous drugs, controlled precursors and essential chemicals, instruments, paraphernalia, and or laboratory equipment, including the proceeds of properties obtained from the unlawful act committed. The penalty of life imprisonment to death and a fine ranging from 500,000 pesos to 10 million pesos, in addition to absolute perpetual disqualification from any republic office, shall be imposed upon a public officer or employee who misappropriates, misapplies, or fails to account or for confiscated, seized, or surrendered dangerous drugs, plant sources of dangerous drugs, controlled precursors and essential chemicals, instruments, paraphernalia, and or of laboratory equipment, including the procedures or properties obtained from the unlawful acts as provided in this act. Criminal liability of government officials and employees. The maximum penalties of the unlawful acts provided for in this act shall be imposed, in addition to absolute perpetual disqualification from any public office, if those guilty of such unlawful acts are government officials and employees. Section 29. Criminal liability for planting of evidence. Any person who is found guilty of planting any dangerous drug, controlled precursors, and essential chemicals, regardless of quantity and purity, shall suffer the penalty of death. Section 30. Criminal liability of officers of partnerships, corporations, associations, or other judicial entities. In any case, any violation of this act is committed by a partnership, corporation, association, or any juridical entity, the partner or president, director, manager, trustee, estate administrator, or officer who consent to or knowingly tolerate such violation shall be held criminally liable as co-principal. The penalty provided for the offense under this act shall be imposed upon the partner, the president, the director, the manager, the trustee, state administrator, store, or officer who knowingly authorizes, tolerates, or consents to use of the vehicle, vessel, aircraft, equipment, or other facility as an instrument in an important sale, trading, administration, dispensation, transportation, or manufacture of dangerous drugs, or chemical diversion, such as vehicle, vessel, aircraft, equipment, or other instrument is owned by or under the control of supervision of the partnership, corporation, association, or judicial entity to which they are affiliated. Section 31. Additional penalty if offender is an alien. In addition to the penalties prescribed in the unlawful act committed, any alien who violates provisions of this act shall, after service of sentence, be deported immediately without further proceeding unless the penalty is death. Section 32. Liability to a person violating any regulation used by the board. The penalty of imprisonment ranging from 6 months and 1 day to 4 years and fine ranging from 10,000 pesos to 50,000 pesos shall be imposed upon person found violating regulation duly issued by the board pursuant to this act, in addition to the administrative sanctions imposed by the board. Section 33. Immunity from the precautions, prosecutions, and punishment, notwithstanding the provision of Section 17, Rule 119 of the Revised Rules of Criminal Procedure and the provision of Republic Act 6981 or the Witness Protection, Security, and Benefit Act of 1991, any person who has violated Sections 7, 11, 12, 14, 15, and 19, Article 2 of this Act, who voluntarily gives information about any violations of Section 4, 5, 6, 8, 10, 13, and 16, Article 2 of this Act, as well as any violations of the offenses mentioned in the conducted by a drug syndicate or any information leading to the whereabouts, identities, and arrest of all any of the members thereof, and who willingly testifies against such persons as described above, shall be exempted from the prosecution or punishment for the offenses with reference to with his or her information of testimony were given and may plead or prove the giving of such information and testimony in bar of such prosecution, provided that the following conditions occur. Number 1. The information and the testimony are necessary for the conviction of the persons described above. Number 2. Such information and testimony are not yet in the possession of the state. Number 3. Such information and testimony can be corroborated on its material points. Number 4. The informant or witness has not been previously convicted of a crime involving moral turpitude, except when there is no other direct evidence available for the state other than the information and testimony of said informant or witness. And last, number 5. The informant or witness shall strictly and faithfully comply without delay any conditions or undertaking reduced into writing, lawfully imposed by the state as further consideration for the grant or immunity from prosecution and punishment. Section 34. Termination of the grant of immunity. The immunity grant to the informant or witness as prescribed in the Section 33 of this Act shall not attach should it turn out subsequently that the information or the testimony is false, malicious, or made only for the purpose of harassing, molesting, or in any way prejudicing the person described in preceding section against whom such information or testimony is directed against. In such case, the informant or witness shall be subject to prosecution, and the enjoyment of all rights and benefits previously accorded in him under this Act or any other law, decree, or order shall be deemed terminated. In case an informant or witness under this Act fails or refuses to testify without just cause and will lawfully obliged to do so, or he or she violate any condition accompanying such immunity as provided above, his or her immunity shall be removed, and he shall likewise be subject to contempt or criminal prosecution as the case may be, and the enjoyment of all rights and benefits previously accorded him under the Act or in any other law, decree, or order shall be deemed terminated. In case that informant or witness referred to under this Act fails under the applicability of the section hereof, such individual cannot avail of the provisions under Article number 8 of this Act. Last, Section 35. Accessory penalties. A person convicted under this Act shall be disqualified to exercise his or her civil rights, such as but not limited to the rights of parental authorities or guardianships, either as to the person or property of any ward, the rights to dispose of such property by any act or any conveyance, and political rights such as but not limited to the right to vote and be voted for. Such rights shall also suspended during the pendency of an appeal from conviction.